Welcome. I'd like to welcome you all to the 2009 Segal Lecture. I can see from many of you in the audience, this lecture is named for Irving Segal, as everybody affectionately knew him as Buddy. Buddy was a graduate, the 1938 graduate of Penn Law School, first in his class, and went on to be really one of this country's great trial attorneys. He represented blue chip companies. He tried hundreds of cases all over the United States and received numerous awards, both for his professional and academics accomplishments. But Buddy, I think, cared deeply about the judiciary and the trial and courts, and it was in his honor that his friends and some of his clients endowed this lecture, a lecture that over the years has attracted Supreme Court justices, solicitor generals, some of the greatest trial lawyers in the United States. And I can say we are delighted and truly honored today to have someone who is truly one of the foremost commentators and observers of the Supreme Court as this year's Segal Lecturer, Linda Greenhouse. Linda's talk today is titled, How Judges Know What They Know. She has covered the Supreme Court for the New York Times for nearly 3 decades. She was the best recognized and simply the best Supreme Court reporter of her time. Indeed, I think many people view her as having created the genre of Supreme Court reporting. In 1998, she received the Pulitzer Prize for her reporting, and a decade later, when she gave up that beat, one wag memorably dubbed her the Supreme Court Whisperer. She comes here today at an inflection point in the nation's history. We have a new administration which is promising a change in government unlike anything we have seen since the Reagan Revolution. Many observers predict there will be momentous changes on the court as well, with as many as 3 vacancies during President Obama's term. So this is a propitious moment, to say the least, for Linda Greenhouse to join us. She began her storied career at the New York Times after graduating from Radcliffe College in 1968. After covering New York State government for several years, she left the Times to earn a master's degree in law from the Yale Law School, where she had as a classmate the person who's introducing her today. Armed with this degree, she returned to the paper to cover the Supreme Court. The rest, as they say, is history. She covered the Supreme Court for most of the 80s, the 90s, and the current decade. In total, she covered 29 sessions, during which 2,700 decisions were handed down. From perspective, her tenure covering the court lasted longer than all of the current Supreme Court justices, save Justice John Paul Stevens. Jimmy Carter was president when she took over the Supreme Court beat. She watched 9 new justices join the court. She witnessed and wrote about the appointment of the first woman justice. She saw the first shot fired in the judicial wars when the Senate rejected Robert Bork, which she called, and I quote, the most riveting public event I ever witnessed at close range. She experienced the tense battle over Clarence Thomas's nomination. She watched the court decide a presidential election, reaffirm the constitutional right to abortion, and protect the original intent of the Second Amendment. The list goes on and on. In short, she has seen it all, reported it all, and figured it all out, demystifying the court and expanding our understanding of its actions. She truly defined the term a Supreme Court observer. She indeed wielded such influence that one federal judge accused some of his colleagues of calibrating their decisions to earn positive press. He called this phenomenon the greenhouse effect. And her output has been as big as her impact. Linda has authored more than 3,000 articles, one well-received book on Justice Harry Blackmun, and a number of articles for law reviews, including one for the University of Pennsylvania Law Review with the provocative title, How Not to Be Chief Justice, The Apprenticeship of William Rehnquist. She is celebrated for scrupulous translations of complicated opinions and trends on the court and insightful writing. Let me give you just 2 of hundreds of examples. She wrote on Chief Justice Rehnquist, I admired Chief Justice Rehnquist as a strategist and tactician. He knew what he wanted and he knew his limits, just as in his weekly poker game. He knew when to hold them and when to fold them. Justice Scalia was a flashier attention grabber, but I never had any doubt that William Rehnquist was the brains behind the court's ascendant conservatives. Then there's what she said about Justice Harry Blackmun, author of the majority opinion in Roe v. Wade, and I quote, "On Harry Blackmun's improbable journey, becoming a feminist icon was perhaps the most improbable destination of all. The long shadow of Roe v. Wade obscures the ambiguities, the halting and tentative footprints that marked Blackmun's path toward a full embrace of women's rights. Even the reality of Roe itself, the extent to which its author's focus was on doctors rather than on women, has been largely lost to myth and the mists of memory." Linda has earned the respect of her peers. She was a highly decorated veteran of the Supreme Court wars, winning several awards in addition to the Pulitzer. She also earned the respect of the men and women she covered on the court. Last year, when she decided to retire from the Times and accept a position as journalist in residence at Yale, 7 justices, including Chief Justice John Roberts Jr., attended her going-away party. That says it all. In July, she penned a summation of sorts for the New York Times, writing, "Sometime during the first of my nearly 30 years reporting on the Supreme Court, a distinct visual image of Supreme Court term took hold in my mind and never let go. The 9-month term was a mountain. My job was to climb it." And climb it she did. It's my pleasure to introduce a writer of the first-ranked, an indispensable source of Supreme Court news, and a journalistic treasure, this year's Segal lecturer, Linda Greenhouse.
Thank you, Dean Fiss, and you'll all be relieved to know I'm not going to give you my memoirs up here. I know that the Segal lecture is supposed to relate somehow to trial advocacy, to his career. Not being an advocate, Dean Fiss gave such a nice introduction, he kind of buried the fact that I'm not a lawyer. I won't talk so much about advocates, but about judges. Of course, the two, advocates and judges, are closely linked, and the quality of the advocacy, no doubt, influences the quality of the judging at least some of the time, maybe not as much as the advocates like to think or like to suggest to their clients. But in any event, having watched the Supreme Court, as you heard, on a daily basis for close to 30 years and having read thousands of Supreme Court briefs, some but not all of which had an impact on the outcome, I got quite interested in the understudied aspect of judicial behavior, the sources of judicial knowledge. How do judges know what they know or what they think they know? So in the belief that I can make this topic fit within the mission of the Segal lectureship, I will proceed. I'll start by reminding you of a startling sequence of events at the Supreme Court last summer. On June 25th of last year, the court ruled that the death penalty is an unconstitutional punishment for the crime of raping a child. The vote was 5-4. Justice Anthony Kennedy's majority opinion relied in considerable part on the conclusion that there was in the country a general consensus against punishing this particular crime by death, and that capital punishment for the rape of a child was therefore cruel and unusual within the meaning of the Eighth Amendment. In support of that conclusion, Justice Kennedy noted that of the 36 states that have the death penalty, only 6 include the rape of a child as a capital offense. So that meant in 44 states, 30 of the death penalty states plus the 14 states that don't have a death penalty, a child rapist could not be sentenced to death. And Justice Kennedy attached significance to the fact that when Congress expanded the reach of the federal death penalty during the 1990s, child rape was not included among the new capital crimes. Now, this case, Kennedy against Louisiana, was among the more high-profile cases on the Supreme Court's docket during the last term. The decision was quite controversial, It was closely dissected both by the dissenting justices and by outside critics. But the court had spoken, and that seemed to be that. Not so fast. It turned out that the majority had made a factual error, a rather glaring one in coming to its conclusion. Within days, a startling fact emerged. It turned out that less than 2 years earlier, Congress had extended the death penalty to child rape as part of a revision of the sex crimes section of the Uniform Code of Military Justice. True, that provision applied only to crimes committed by military service members, and the relevance of that provision to the court's Eighth Amendment jurisprudence was not completely obvious. But what was obvious was that the majority's assertion that there was no federal law on the books that made the rape of a child a capital offense was simply not true. So, as I mentioned, this was a high-profile case. It was on the court's docket for months. Yet not only did the parties to the case fail to bring this recent legislation to the justices' attention, neither did anybody else. Among those who let the court down was the federal government itself, which is usually quick to weigh in through the Office of the Solicitor General in any Supreme Court case that could conceivably have an impact on a federal statute or on any other federal interest. The government, in fact, took no position and filed no brief in the case. In fact, the new law was brought to light by a civilian specialist in the military death penalty who runs a blog devoted to the work of the U.S. Court of Appeals for the Armed Forces. Well, there followed a flurry of activity as both the state of Louisiana and the U.S. Solicitor General filed briefs asking the court to reconsider the decision, which the court declined to do. A lot of motion practice back and forth, and on October 1st, the court denied the request over the dissenting votes of Justices Thomas and Alito. The 5 justices in the original majority, including Justices Souter and Ginsburg, filed an explanatory statement. Those 2 justices noted that the military had long had a death penalty for rape, although had not carried out any execution since 1961, and that the effect of the 2006 law was quite unclear. Quote, in any event, authorization of the death penalty in the military sphere does not indicate that the penalty is constitutional in civilian context, unquote. Well, this tale raises, I think in quite dramatic and concrete fashion, the question that I'd like to consider this afternoon. How do judges know what they know, or what they think they know? As Tocqueville famously observed, this is a society that turns to the courts to resolve its most pressing disputes. Judges play a significant role, some might say an outsized role, in the life of the country. We expect them to know the law, and they do. But resolving legal disputes is not an abstract exercise. Judges have to apply the law. Indeed, they have to decide what law applies to the cases before them, cases that don't arrive on their dockets as abstract propositions, but rather as messy human conflicts that were not amenable to any easier or less expensive resolution than bringing them to court. Well, most people would probably respond to the question by thinking of scientifically or technologically complex questions or the economic assumptions that go into deciding, for example, an antitrust case. Cases that call on specific fields of expertise, of course, present challenges to the generalists who serve as our judges. Quote, look, I don't know anything about this. I'm not a naval officer, unquote. Justice Breyer observed to counsel in an oral argument earlier this term on whether the Navy should be bound by environmental restrictions on its program of testing sonar in the deep ocean. The district judge who initially functioned on that case, quote, doesn't know about it either, Justice Breyer said from the bench. But whether a judge has personal knowledge of, for instance, the effect of sonar on marine mammals is not really my point. All kinds of cases, including the totally mundane, call on judges to base their judgment on facts or on conclusions based on assumed facts. Were the police reckless when they gave chase to a speeding driver and forced him off the road and into an accident with devastating injuries? Reckless means reckless under the circumstances. And what were those? And how does the judge really know? Trial judges, who are often referred to as finders of fact, of course hear testimony from witnesses, some of whom may be experts, and reach their conclusions in time-honored fashion according to the burden of proof in that kind of case. The preponderance of the evidence standard in most civil cases simply means more likely than not, and judges quickly become accustomed to making these kinds of evaluations. The real challenge, I think, comes at the appellate level. An appellate judge is bound by the record created below either in a federal agency or a trial. He or she can set aside only those factual findings that are clearly erroneous or unsupported by substantial evidence, a very difficult burden for someone challenging a lower court decision or an agency decision to meet. How comfortable should we be with a clearly erroneous standard? I can describe one area where I know appellate judges are distinctly uncomfortable: immigration law. The U.S., as you know, I'm sure, is deporting would-be immigrants by the hundreds of thousands annually. And the great majority of these individuals are unrepresented by lawyers when they appear before the immigration judges who will decide their fate and who process cases at about the rate of 6 a day. Adverse decisions by the immigration judges can be appealed to an administrative body called the Board of Immigration Appeals. Here, too, most immigrants are unrepresented due to so-called streamlining changes imposed by the Bush administration. This board largely abandoned the practice of sitting in panels of 3 members and of issuing written opinions. Rather, single officials, acting alone, hear these appeals and decide them summarily without making a written record or explaining their decisions. The result has been an explosion of immigration appeals to the federal courts of appeals. These appeals tripled to about 12,000 a year over a 5-year period. Roughly 1 in every 3 Board of Immigration Appeals decisions is now appealed to a federal appeals court. Immigration cases make up nearly half the docket in 2 of the biggest and busiest federal appellate circuits, the 2nd and the 9th. It's not only the workload that disturbs the judges who have to handle these cases. The problem is that in so many of these cases, many of which involve potentially life or death issues of asylum, the appellate judges have so little to work with. The decisions of the Board of Immigration Appeals are presumed to be correct and can be set aside other than for some error of law, only if they're based on clearly erroneous findings. Judges have told me that they frequently feel at a gut level that the findings may well be erroneous, but that's something short of clearly erroneous. Judge Richard Posner, no soft touch, of the 7th Circuit, complained in a published opinion in 2005 that, quote, the adjudication of these cases at the administrative level has fallen below the minimum standards of legal justice, unquote. And there's little doubt that that's a correct appraisal. But still, Board of Immigration Appeals decisions are being affirmed by federal appeals courts at the rate of about 85%. One judge told me on a panel that I moderated last summer at the American Bar Association's annual meeting that when he thinks about the immigration cases on his docket, he has trouble sleeping. How do judges know what they know? It might be tempting to assume that if judges could only hear a tape or watch a film, factual ambiguities could be dispelled and judges would know what they need to know. The Supreme Court actually conducted such an experiment. It didn't regard it as an experiment, but functionally it was, in a case decided 2 terms ago. The question in Scott against Harris, which I alluded to earlier, was whether a police officer acted reasonably in chasing and forcing a speeding driver off the road. The driver, a teenager who was not suspected of any offense other than speeding, was rendered a quadriplegic by the ensuing accident and sued the police officers for violating his right to due process. A video camera mounted on the dashboard of the police car recorded the chase, and the Supreme Court put the 6-minute video up on its website as part of the majority opinion, which concluded that the fleeing driver was so obviously a menace to public safety that, quote, no reasonable juror would have quarreled with the officer's decision to use deadly force to, quote, take him out. And indeed, the video showed a scary drive at breakneck speed on a dark and winding country road. But the vote in Scott against Harris was not unanimous. It was 8-1. The dissenter was Justice John Paul Stevens, and certainly Justice Stevens is a reasonable man, or at least as reasonable as the rest of his Supreme Court colleagues. He had, in fact, learned to drive many years ago on dark and winding roads, and he did not view the driver's behavior as justifying deadly force. My current colleague, Professor Dan Kahan of Yale Law School, was significantly intrigued by this case to conduct a social science experiment showing the tape to a diverse sample of 1,350 people and studying their reactions. Well, it turned out that most of the respondents thought the Supreme Court was correct. Not all of them did, and the demographic portraits of the 2 groups proved to be quite interesting. Those who agreed with the court were most likely to be white, male, and from the South or West. Those who disagreed were more likely to be non-white, female, and from the Northeast. In other words, responses to the video on which the Supreme Court based its conclusion turned out to be, at least to some measurable degree, culturally determined. So who is a reasonable juror or a reasonable justice? How do judges know what they know? Sometimes judges feel compelled to go outside the record and see things for themselves. Among the current members of the Supreme Court, Justice Breyer is the most likely to want to assure himself of the full factual context of a case. A law review article several years ago noted with some bemusement Justice Breyer's citation in an opinion for the court to a book called How to Buy and Care for Tires. True, the case, which had to do with expert testimony, had its origins in a tire blowout, but neither the tire book nor two other similar books that Justice Breyer cited had been called to the court's attention by any of the briefs. The law review authors noted, "It is safe to conclude that How to Buy and Care for Tires is not part of the historically recognized canon of legal information." It was, however, not an aberration. The citation of non-legal materials appears to be increasing in all courts, Frederick Schauer and Virginia Wise note in this article. Citations are commonly made to such sources as textbooks, academic journals in fields other than law, such as economics or psychology, daily newspapers, and popular culture. Frequently, these are not found in the briefs, but rather are ferreted out by law clerks. Ease of access through online databases is undoubtedly a big contributing factor. The practice of judicial extra record fact-finding is interesting, but it doesn't really shed much light on our question. I think more to the point is the type of case that comes saturated with facts so that judges don't have to look under any rocks. And yet, how often have we all seen two judges look at the same fact pattern and come to opposite conclusions? The videotape in Scott against Harris presents a subset of this issue because it deals with culturally influenced cognitive perception of visual images. More common is the judicial behavior manifested by one of the better-known recent Supreme Court decisions, the Lilly Ledbetter case. And I'm sure you recall it. This is the Title VII pay discrimination case in which a woman's claim of unequal pay was held foreclosed because she hadn't filed within 180 days of the discriminatory act the company's decision to pay her less than her male coworkers. This case presented a fairly straightforward claim of statutory interpretation, namely, what is the discriminatory act under Title VII? What is the unlawful employment practice? Was it the initial pay-setting decision made years before Lilly Ledbetter discovered it on the eve of her retirement? Or was it the issuance of each subsequent paycheck that reflected, or more to the point, perpetuated the initial discrimination? The Equal Employment Opportunity Commission had long embraced this latter definition of the paycheck accrual rule, but the Bush administration, entering the case on behalf of the employer, repudiated the agency's position. The company won by a vote of 5-4. Justice Alito's majority opinion began by asserting that Ms. Ledbetter's case was governed by, quote, established precedent in a slightly different context. The established precedent that he cited holds that the 180-day charging period runs from any, quote, discrete act of discrimination, such as, quote, termination, failure to promote, denial of transfer, refusal to hire. All the majority did was add a pay-setting decision to this list. That was the slightly different context, and that was the end of the case as far as the majority was concerned. But Justice Ginsburg pointed out in dissent that, as she put it, the realities of the workplace showed that the majority had made a category error. Pay discrimination did not occur in a slightly different context. It was, in fact, completely different from the public, or at least the immediately ascertainable, events of termination, failure to promote, or refusal to hire. Quote, compensation disparities, in contrast, are often hidden from sight, Justice Ginsburg wrote. She noted that this very employer kept salaries confidential, as do some 90% of all private employers. Well, the Ledbetter case is history, but Congress, as you know, voted to overturn the decision, and the Lilly Ledbetter Fair Pay Act of 2009 was the first bill that President Obama signed into law. So my effort is not to rehash the arguments, but to underscore the point that here was a case in which neither the facts nor the precedents were in dispute. What divided the two sides was how the justices saw the facts and how they understood the relevance of the precedents. Did it matter that Justice Alito has been a government employee for his entire career? There may well be secrets in the federal workplace, but who gets paid what is not usually among them. But the private sector is very different, and many women over a certain age, certainly of Ruth Ginsburg's age, could tell stories much like Lilly Ledbetter's. So how do judges know what they know? To at least some degree, they know it from the lives that they've lived. In other instances, the salience that judges ascribe to facts or to presumed facts seems simply to reflect a cast of mind. In his vigorous dissenting opinion in last summer's detainee case, Boumediene against Bush, Justice Scalia warned that restoring the federal court's jurisdiction to hear habeas corpus petitions from Guantanamo detainees, quote, will almost certainly cause more Americans to be killed, unquote. The decision was devastating, he said. There followed, in his dissenting opinion, a long paragraph recounting incidents of prisoners, at least 30, he said, who had returned to the battlefield or resumed their terrorist ways after being released from Guantanamo. Although the paragraph contained a number of citations to official-sounding reports, it was promptly denounced as, quote, the perpetuation of an urban legend by the Seton Hall Law Center for Policy and Research, which claimed that Justice Scalia's sources had exaggerated or misstated the known facts. So the point here is not whether the number of released detainees was 30 or half that or fewer. Rather, what I think is notable is that Justice Scalia regarded the post-release behavior of any detainees as having any relevance to the question before the court, which was whether Congress's stripping of the federal court's habeas corpus jurisdiction was constitutional. In fact, of course, not a single detainee had been released by means of a habeas corpus petition or by order of any court, nor has any been released by order of any court even today. All had been released through some version of executive grace. Perhaps Justice Scalia's message was that these unilateral executive branch decisions had been bad, but that judicial decisions following adversarial hearings and full review would be even worse. Why that should be so, Justice Scalia doesn't tell us. Predictions like this, based on judges' extrapolation from facts, are risky. Justice Breyer, dissenting from the court's decision some years ago to uphold the use of publicly financed vouchers to pay for parochial school tuition, warned of an ensuing risk of, quote, religiously based social conflict that would be, quote, potentially harmful to the nation's social fabric. 7 years later, it hasn't turned out that way. The voucher movement that looked so powerful earlier in the decade has basically gone nowhere, not because of civil strife, but because of resistance from organized labor and ordinary taxpayers. Both Justice Scalia in Boumediene and Justice Breyer in the voucher case voted their fears. Breyer's fears, in any event, have not come to pass. But in thinking about what judges know or think they know, visceral responses such as these can't be overlooked. So let me conclude with some musings on judicial behavior in cases concerning abortion, a subject that, to a remarkable degree, has been the province of the courts. 2 years ago, the Supreme Court upheld a federal law called the Partial Birth Abortion Ban Act of 2003. This decision, Gonzalez against Carhart, was based on a remarkable collection of premises indulged in by the 5-4 majority and by the author of the majority opinion, Justice Kennedy. One was that, quote, it is self-evident, unquote, that a woman whose doctor performs an abortion by the method that the statute criminalizes, quote, must struggle with grief more anguished and sorrow more profound, unquote, when she realizes what has happened. What's remarkable here is not only the patronizing assumption that reduces a woman seeking to terminate a pregnancy to a childlike state of ignorance, but also that Justice Kennedy offers no citation, no factual backup for his assertion about what goes on in a woman's heart or head. It is simply self-evident, Justice Kennedy said. And the majority, along with him, buys into the myth of the existence of a post-abortion syndrome that has been abundantly discredited in the psychological literature, as well as in briefs presented to the court by medical organizations as long ago as 1989. An editorial in the Medical Journal of Obstetrics and Gynecology, after Gonzalez came down, criticized Justice Kennedy for, quote, his rejection of evidence-based practice by failing to include a single medical reference in support of his opinion, And the title it put on this editorial is kind of interesting. The editorial was entitled, "The Supreme Court Joins the Multi-Specialty Group Practice of the Congress and the President." So finally, let me offer a more heartening example of a judge's response to this freighted subject of abortion. The year after Justice Sandra Day O'Connor joined the Supreme Court, the court was faced with deciding the constitutionality of restrictions on access to abortion that had been adopted by the city of Akron, Ohio. The majority declared these unconstitutional on the basis of Roe against Wade, which had been decided just 10 years earlier. Justice O'Connor, confronting her first abortion case on the Supreme Court, dissented in an opinion that was a broadside attack on Roe itself, noting that premature infants were being saved at younger and younger gestational ages. Quote, "It is certainly reasonable to believe that fetal viability in the first trimester of pregnancy may be possible in the not-too-distant future," Justice O'Connor said. Quote, "The Roe framework, then, is clearly on a collision course with itself as the point of viability is moved further back toward conception," unquote. Well, whatever one thought about Roe against Wade as law, Justice O'Connor's reasonable belief was simply incorrect as a matter of obstetrics and neonatology. There's no prospect of fetal viability moving back into the first trimester. The medical community then made it its business to inform Justice O'Connor of this fact. 6 years later, in a subsequent case in which the court's continued adherence to Roe against Wade appeared to be directly at issue. In this case, Webster against Reproductive Health Services, the American Medical Association, the American Academy of Pediatrics, and other groups filed a brief explaining the existence of an anatomic threshold at about 24 weeks that, due to the incapacity of the fetal lungs, makes survival impossible even with mechanically assisted respiration. Quote, "Improvements are not expected in the foreseeable future," unquote, the brief concluded. Neither in Webster nor in any future opinion did Justice O'Connor refer to this brief, but she never again mentioned the so-called collision course of Roe against Wade, and she came to play, as we all know, a key role in preserving the constitutional right to abortion. So, maybe a good judge is not necessarily one who knows everything, but one who is willing to learn. Thanks very much.